Thank you, Mr. Chair. Members of the committee, Bruce Riley with vote. Obviously, a lot was said, so I'm just going to try to keep it to a couple of points here. And just getting back to the challenge of going through post-conviction to get your merits heard. You know, most people who get convicted and then they deal with their direct appeal, the real merits of what went wrong in your case are not eligible to be reviewed. So the direct appeal barely ever gets somebody out. And then the folks that are then left unto their own devices to try to get into court, many of these cases that we're just talking about are oftentimes people who struggle with literacy. They may struggle with language barriers. They struggle with education levels. And I helped plenty of people work on petitions while I was incarcerated and I was serving as a jailhouse lawyer. And I had to learn the law myself. So they were relying on someone who didn't even have a law degree to do their best. And then I wasn't even allowed to go into court and explain the things that I learned. They had to then go into court and try to say, Your Honor, this is the situation. And just as was said, hardly any of those cases get through the procedural bars, and you don't even get your merits heard. And so we hear about these stories around the country, including disproportionately here in Louisiana, people who get their convictions finally looked at and overturned, and it's after 20 years, 30 years, even 40 years. And you know what? They could have done that after 20 minutes, 30 minutes, 40 minutes. But because of procedural bars, they never got to the merits. So it's disingenuous to say, this has been ruled on time and again. The reality is, when D.A. Williams is talking about these cases, many of them never have looked at the merits ever. And then going back to everyone says that they're not guilty or whatever, they're all this and that, 95% or more cases are guilty pleas. So we're only talking about a very narrow section of people who disputed their guilt, who then are still disputing their guilt decades later. That's like a tiny fraction of people. And for us to be unwilling to look deeply at those cases, including non-unanimous jury cases, where, in this state...
Over half the cases we reviewed were guilty pleas, by the way.
Yeah. So, and the thing is, as we just heard,
that he
people
will let go. But
convinced
anyway,
to be pled guilty to crimes.
I don't want to take any of
and you're being threatened with, you're going to get life if you don't plead to this, on and on. You're going to get the death penalty if you don't plead to this. If you plead to this, we'll give you parole after 10 years, 6 months. If you go to trial and you lose, you're getting the chair. Well, what does your mama tell you to do? Your mama's going to say, take the 10-6 opportunity. And then you know what? 9 years into it, they say, yeah, we're not doing the 10-6 anymore. And then you're still there 40 years later. That's why this body had to pass a law to look at these 1970s lifers, because it was unjust. And when you sign a guilty plea, that's a contract. You're entitled to the customs and the norms if it's not explicitly said in the contract. And so a lot of people who had parole eligibility had that rug taken out from under them, and so they never even get a chance to see the parole board. So there's a lot of things that weren't said based on this idea that we have this perfect system that's just chugging along, and now Jason Williams is disrupting this perfection. If we think, considering everything around children being given mandatory life sentences, non-unanimous juries, police misconduct, Brady violations, Batson, where you could manipulate who's on the jury, all the way up to 1986, I believe it was, Crawford, where you can introduce hearsay evidence up till about 2004. This idea of getting a clean, smooth system is actually kind of new. And yet you got people who've been locked up since the 70s, the 80s, the 90s, 2000s. And the idea that the predecessors of Jason Williams were just squeaky clean. Harry Connick admitted to the U.S. Supreme Court he hadn't read a Supreme Court case since law school.
Okay, thank you, Mr. Riley.
I'll leave it at that.
I'm going to
Thank
stick
you.
to the chair's rule. Appreciate you. Mr. Claude Michael
Como.
Okay. I see that go ahead.
So my name is Claude Michael Como. I'm a staff attorney at the Promise of Justice Initiative. I was going to talk about non-unanimous juries convictions in relation to what we're talking about here today. So here today, we know how egregiously wrong non-unanimous jury convictions were. It's a system designed to fast-track black convictions, silence the voices of black jurors in order to do that. And I think in relation to what we're talking about today, it's important to know how long that law lingered in Louisiana. It was propagated into the Louisiana Constitution in 1898, and it wasn't until 2020 until the United States Supreme Court said, hey, you got to cut it out. Up until that time, it's not like the U.S. Supreme Court was just like, hey, I just found about this issue in Louisiana. People had been fighting that issue constantly and running up against appellate courts that told them they weren't claiming anything that was wrong. It was just fine. All the leaders in Louisiana were telling the people that were saying they had been suffered a constitutional violation that their conviction was fine. And it wasn't until, the U.S. Supreme Court says, hey, you need to stop doing that, is when it then became apparent to Louisiana and the appellate courts that had been constantly denying applications that it was not fine, that it was an unconstitutional issue. So after that, I just want to restate some misstatements that have been raised here. Whenever Reddick came down, that was the decision from the Louisiana Supreme Court that said that, they weren't going to issue retroactivity. That was because they said they could not. They said that it was on this legislature to make that change to go retroactively. But they did not prohibit DAs from reaching a different conclusion. They explicitly actually said that they could. They said that we note, without commenting on its validity, that the legislature has granted district attorneys with judicial approval to authority to agree to individualized relief. At that time, they're talking about 930.10, and then the AG challenged that law too. So, in response to that, the Supreme Court said that with or without any legislation, the Louisiana Constitution, at Article 5, Section 26, provides the DA absolute discretion to not oppose or even join an application for post-conviction relief. And a lot's been said today about the need for adversarial hearings. But in that same decision, they say, in short, our decision does not mandate that collateral review of criminal convictions be unnecessarily adversarial, nor does it serve as a bar to cooperation between parties in post-conviction proceedings to achieve the ends of justice. So I think when we're talking about philosophical differences, we need to talk about which party has that philosophical difference, because the Louisiana Constitution seems to provide that district attorneys should be seeking out justice and not convictions, or defending convictions that they know that can't stand. Thank you.
Thank you, Mr. Como. And you are Mr. Ward.
Yes, good afternoon. My name is Hardell Ward. I'm the Community Impact Director at Promise of Justice. I want to first clarify some of the information that was stated today. The document that AG Burrell put of the stages is what we call the 9 boxes, sometimes the 11 boxes, how you talk about it. As Bruce alluded, you don't get a chance to bring those claims with counsel, but 2 of those boxes. The rest of those steps, individuals have to do that without counsel, without a right of counsel. Usually they'll either have to do it pro se on their own, based on their own understanding of the law, or with inmate sub-counsel. Part of the reason why New Orleans has such a high incidence is because there are resources there, and there are attorneys like myself who are there, who are in that city, who are able to get access to those records to review those cases and bring. It is nothing more than New Orleans is the seat of the state, and it does have the resources, and that is where organizations like myself, IPNO, and others are placed. Second, the issue of CRD is unusual. It is not. Before I was community director, I was the managing attorney of the Jim Crow Jury Project. In doing that work, I traveled to every parish in the state. I have met with pretty much every DA. If I haven't met with them, I've emailed or communicated by phone. The CRD is novel only in name. Jefferson Parish has the CID, the Conviction Integrity Department, which is staffed by a former AG, that is doing the exact same purpose. EBR doesn't have a division in that name, but when I met with them, they had a specific first AD, the chief of appeals who we spoke to, and other members of the staff. Shreveport made available their first AD, and the DA themselves to review cases. Many of the districts in the state, the DAs went through every case with me, and we reviewed every single non-unanimous jury case. And each of those DAs made their decision of whether or not they believe relief can be granted. This is how the process has always been done. What is new now is Bayou Mama Bears or whatever groups specifically targeting New Orleans because the numbers are so high. To Mr. McGeeh's question of what about the numbers, so many? As Royce Plessis stated, there was 2,700 instances of multiple bill, and and you'll see the information, in 2017, New Orleans was the wrongful conviction capital of the world, of the nation, or maybe the nation, I don't know if this is the world. Of course, it would lie in New Orleans. Of course, that's what the numbers. But it shouldn't surprise you, for I know some of your districts, many of your DAs resolved all of their non-unanimous jury cases within the first 2 years and granted relief. So while it may be 350 seems like a lot, the percentage of cases that were eligible is actually lower than other districts throughout the country. I think that's important to realize. We're focusing on New Orleans only because New Orleans is more public with it, even though they're accused of not being transparent. And New Orleans is considered of doing more when these same issues abound. Many DAs, as DA said about potential Brady issue and potential exposure, that is the exact reason many DAs have told me why they can't move forward, why they can't have a public process. This board wants an open record to review the records. That is exactly what we've asked for repeatedly to this legislature for non-unanimous jury convictions. Let us review. That is why we have asked for a motion for new trials, so that there will be an adversarial process to actually determine guilt or innocence, rather than us simply picking and choosing and allowing different fact patterns to reach it and decide what they want to do. If we're going to look at post-conviction relief, we need to be honest with ourselves that this is a common practice, and a practice that breeds faith in our citizens to know that cases will be reviewed, then that innocent people will not be locked up. If we're going to focus on crime, as Mr.
We've
Williams
let
stated,
you go about almost 4 minutes.
Oh, I apologize. I don't see the time. I
That's
apologize,
okay. But we're also concerned about the guilty people, and the out of the cases that we've reviewed so far, none of them were factually innocent. They don't even claim to be factually innocent. But anyway, thank you all for your
Can I
testimony.
respond to that? No.
I'm going to call up 3 more.
And I'm kind of confused, really, because when I came, I drove all the way up here, and I thought this conversation was going to be about one thing, and it started morphing into something else. But anyway, District Attorney Williams was talking about trust and confidence in the system. 24 years ago, my son and my daughter-in-law was killed. And my belief, it could have been prevented, because my daughter-in-law complained to the police department that her ex-boyfriend was stalking her. They dismissed it. 2 months later, he set her car on fire. They dismissed it. Mardi Gras of 2000, he killed both of them in front of her mom. And then the police realized that, wait a minute, this little girl was telling us the truth. Fast forward, in 2022, my brother was killed in road rage. A guy hit his car, jumped out the car, and shot him. That district attorney's office, victim assistance program, walked me through that whole process. That didn't happen when my son got killed. That didn't even exist. So when we talk about trust, how people show up, that's how people trust up. Bruce mentioned, I've been hearing all this about adversarial process. This is supposed to be a truth-seeking process. Bringing people to trial is supposed to be trying to find the truth, not kill my dog, I'm going to kill your cat. And that's all I heard today, is folks just trying to one-up the next person. I think to be fair in this whole process is that we have to look at the laws that this body has created. In 1990, that's when all this post-conviction stuff started. But it started primarily because when the Louisiana Superior Court made DA files and police report public records, and people started applying and getting them and finding out they was in prison for something they didn't do, this body changed Title 44, public records, that folks who were in prison were deemed to be non-persons when it came to public records. So when we talking about being fair, being transparent, we got to start looking in the mirror, because we kind of like contribute to where we're at today. And I was glad most folks was talking about post-conviction, and they kept admitting that the first thing I told my law clerks, let's see, can we procedurally bar them? And if anybody look at a post-conviction application, the first 3 questions past your name is give me the date that your appeal was final. They don't look to go to the merits of a case. So when you see these cases coming back years later, that's what it's about. And I'm going to share my case. I went to prison when police reports wasn't public record. 19 years into my prison sentence, they found out the victim identified somebody who was already in prison. Thank you.
Thank you, Mr. Anderson.